Good afternoon, or good morning, I guess. I'm James Wood of the Legal 500, and welcome to our webinar, The Investment Landscape in Cyprus, Challenges and Opportunities. I'm pleased to say we have with us today various partners from C. Samir & Co., including the firm's founding partner, CEO and practice head, Charalambos Samir. Mr. Samir founded the firm in 2011 to assist Cypriot and international businesses on a range of complex cross-border matters. The firm's since grown into one of the leading regional boutiques, one that is active in 65 jurisdictions globally. I think 65 is correct. Is that
correct? That is correct, yes.
I like my last count. So the firm now represents a large range of clients, from private individuals to large corporates, including major banks and financial institutions, but they're particularly active in advising trusts and investment firms. So I'm pleased to say that today we'll be joined by several of Cyprus's leading representatives from that space, and we hope to hear from you all. We started slightly early. I can see people are joining us now. So just to say, throughout the session, if you do have questions, please ask them in the Zoom question box. It's fairly easy to use, and we'll try to address as many of these as possible as things go on. Also, obviously, we're making a recording of this webinar. There are a number of people in markets that can't join us today, the US, Asia, because time differences and whatnot, but obviously we'll be putting this online for the benefits of anyone interested in Cyprus watching this. Please do write to the firm with any questions you may have that arise from their presentations. Okay. Well, today we'll be hearing from partners from the firm. I already mentioned the managing partner. We will be hearing also from Andrea Hachigiorgiou, Natasha Pita, and our first speaker today, Athena Katiri. So Athena, please, you want to take us away.
Thank you very much, James. Thank you, Ben. It's a pleasure to having this webinar with you guys. So welcome, everyone. We'll be introducing a lot of challenges and opportunities faced in the Republic of Cyprus post-COVID-19 era. And I'm going to introduce to you the role of e-commerce and the legal framework governing it. So, over the past few months, we have witnessed an unprecedented sequence of events which not only affected our way of living and the healthcare system, but also threatened to unbalance businesses and the economy on a global basis. Global markets have become increasingly complex nowadays, and it is likely that companies will be faced with a dreadful financial turmoil, which will potentially and inevitably adversely affect their business value. Hopefully not. COVID-19 has provided the greatest incentives for further technological development. It is notable that information technology and digital infrastructure play a vital role in our lives because of the ability to ensure smooth business continuity during such unfortunate events, as well as to provide great opportunities for developing nations to climb up the economic ladder. All organizations must place their highest importance, more than ever before, in assessing their current IT infrastructure and evaluate their need to invest in technological upgrades. This will enable businesses to manage possible risks by minimizing potential harm, especially during economic downturns. After COVID-19 period, there will be a fundamental need for companies to adjust their operations and workforce with empowered data and plan for long-term goals. Organizations, of course, are expected to build more equitable, inclusive, and resilient environments that are better prepared to overcome similar uncontrollable natural forces. This will ensure their long-lasting sustainability, effective business decisions, and continuous growth. If anything, this pandemic highlighted the weakness of many organizations to adapt to the 2020 technological advances, as they were fearful of its associated expense. In addition, it strengthened the assumption that you can either innovate and be ahead of competitions or simply die. Therefore, placing E in front of any process or function appears to be the magic prescription for long-term success and rapid returns for enterprises, since it proved to be resilient even to this pandemic. So, e-commerce is the use of electronic communications and digital transformation processing technology in business transactions in order to create, transform, redefine relationships for value creation between or amongst organizations and between organizations and individuals. There are several factors that constitute the importance of having e-commerce business. Some of the most important ones are the following. Ideal for selling products with no geographical limitations. No time limitations, as it offers the possibility of projects to be worked on nearly around the clock due to the time difference between countries. There is a variety of telecommunication modes, as it is easier, cheaper, and quicker, and also increase incoming traffic on your website, thus boosting your marketing strategies and therefore improving the company's sales through social media channels, which is the ultimate trend nowadays. Also, firms have greater freedom to locate their economic activities by creating greater competition among regions in infrastructure, labor, capital, and other resource markets. Using an e-commerce website for shopping is rather more convenient than going to a physical store. Also, firms can choose their tax authority and other regulations to apply to their business, and it provides efficient market operation as it works on a 24/7 basis. Also, it eliminates intermediaries, reduces the cost in the production and distribution value chain, with cost reduction, lower end customer prices, and higher profit margins. Also, it allows payments to be done in multiple ways. And as we all know, online stores are less expensive to maintain than physical stores. In addition, customers can access databases or manuals directly by reducing cost or improving quality of service. And this immediately cuts cost while generally improving the quality of the service. Also, it provides convenience of having purchases delivered directly to you. And with e-business solutions, companies can get better insights into their audience and improve customer service. This is because a person is able to buy or sell products online from any remote place with ease. E-commerce encourages companies to develop innovative ways of advertising, delivering, and supporting their products and services. Last but not least, e-commerce business is easy to set up. You simply register a company in the country, you build a website, you connect the website to a payment gateway, and you open a merchant account. A merchant account is a buyer account specifically for the funds which you will be accepting online. And thereafter, you open a business buyer account where the funds from the merchant account will be transferred afterwards for security purposes. Lastly, is the use of marketing means in order to advertise your products. Moving on to the applications. The major application is the business-to-business and business-to-consumer applications, which help consumer preferences and consumer markets developing economic infrastructure for challenges of the future. E-commerce has revolutionized business by changing the shape of competition and by creating an e-commerce marketplace for consumers and businesses. The two major e-commerce applications fall in the categories outlined here below, along with their respective advantages. B2C e-commerce reduces transaction costs by increasing consumer access to information and allowing consumers to find the most competitive price for a product or service. B2C also reduces market entry barriers, since the cost of putting up and maintaining a website is much cheaper than building a traditional structure for a firm. Now we move on to the business-to-business e-commerce, which is consisted of four major advantages. Firstly, is the reduction of the share cost, as there is no need for buyers to go through multiple intermediaries to search for information about services, suppliers, products, and prices, as it was traditionally made. In terms of effort, time spent, the internet is much more efficient information channel than its traditional counterpart. Secondly, is the reduction in the cost of processing transactions, for example, the invoices, the purchase orders, and the payment schemes, as B2B allows for the automation of transaction processes and therefore the quick implementation of the same compared to the communication channels. Thirdly, online processing improves inventory management and logistics, as through B2B e-market suppliers are able to interact and transact directly with buyers, thereby eliminating intermediaries and distributors. Lastly, amongst the most obvious benefits of e-markets is the increase in price transparency. The gathering of a large number of buyers and sellers in a single e-market reveals market price information and transaction processing to participants. In this context, buyers are provided much more time to compare prices and make better buying decisions. Therefore, now is the time for the organizations to find possible ways that could convert these unprecedented events into an opportunity to reform certain approaches, to set up a plan in order not only to retain their businesses, but also to shift to the next normal. Based on researches, the percentage of online shopping during COVID-19 has doubled. We firmly believe that the monetary effects of the virus will be strongly aligned with the psychological ones on consumers, meaning that even if the virus is contained, people will prefer online shopping from now on. This should come at no surprise though, as internet connectivity penetrates the world and online shopping becomes increasingly convenient for everyone. Therefore, setting up your business online with the foundations of e-commerce or shifting your existing business online is considered to be the next normal. The internet has changed the way business is done across the globe. With a potential customer base of over 2 billion active internet shoppers in 2020, businesses can't afford to ignore e-businesses. E-commerce is regarded as one of the most important options available for businesses, and for those utilizing same, they automatically gain a competitive advantage in the market. Selling your products or services online is like having a shop that is active 24/7. It's like having a shop which is available worldwide. Here you see, based on a study in Europe, 55% of consumers are shopping on mobile. It's quite enough though, right? A study found that more than 60% of customers report preferring having websites, applications, chatbots answer their queries. This is because of the faster response time, and experts predict that this percentage will be increased to 80% by the end of 2020. Also, internet spending in Cyprus on goods and services is approximately at 57%. It's expected to have a tremendous growth by the end of the year. Also, 85% of the world's internet users shop online. Customers are expecting more and better payment options, which now are available. And streaming video on websites can be eye-catching and one of the most attractive trends in e-commerce. Customers say that they prefer to watch product preview prior to making a purchase, so now this will be available. As e-commerce grows and further exploits the attributes of the internet, it will likely have a significant effect on national economies and industry structure. E-commerce has come to take two significant roles in the reorganization and the conduct of business. First, as a more effective and efficient channel, as well as an aggregator of information. And second, as a potential mechanism for a free market operating under a healthy competition. The internet's ubiquity, interactivity, ability to integrate data platforms and distribute intelligence allows e-commerce to discover new markets and consumers, fostering economic specialization and increased productivity. Consequently, information and communication technologies accelerate the trend towards globalization, integration, productivity, improvements, and gains in welfare that have been underway for many, many years. E-commerce undeniably represents the new frontier in business activities. The legal environment in which it is developing and the instruments adopted in order to regulate it have an important role to play in realizing its potential. The legal framework, though, governing e-commerce in the Republic of Cyprus is the Electronic Commerce Law of 2004. The law aims at ensuring the free movement of information society services between the Republic of Cyprus and the European Union and the European Economic Area member states regarding the establishment of service providers, commercial communications, the conclusion of electronic contracts, the liability of intermediaries, out-of-court dispute settlements, codes of conduct, ways of legal protection, and cooperation between the member states. Additionally, the law regulates the online activities such as the information services, the advertising and marketing online, selling of products and services, and entertainment services as well. However, it must be stated that there are much more important EU legislations which highly affect e-commerce and should be taken into consideration prior to establishing your e-commerce for your businesses. These are the Distance Selling Directive, the e-Signature Directive and Data Protection, the Payment Services Directive, and the Consumer Rights Directive. Finally, the Cybersecurity Act. So, thank you everyone for listening. May I introduce my colleague Andrea, who will be speaking about the contracts.
And Natasha, just before Andrea joins us, I just want to say that obviously e-commerce is hot in Cyprus, and you've kind of outlined some of the reasons that it's a field of concern, I guess, or something to take seriously. I just wondered if any of the attendees, people watching this webinar, have faced any challenges there, particularly for kind of GCs or managing directors from, I guess, businesses that are not directly in the e-commerce space. So if anyone's facing challenges, whether in terms of e-commerce law or strategic business challenges, please let us know any questions you have in the questions box. We'll get around to them later. That's all I want to say.
Thank you. Thank you.
Good morning, everyone. Unfortunately, my presentation will not be as interesting as my colleague Athena. However, I do find it quite important because it relates to contracts. As we all know, in all industries, we have contracts. So now with the new pandemic, we see a lot of challenges. So we will we'll start our presentation and we will discuss about contracts under the Cyprus law. However, we will have to focus on the breach of the. It will be more proper to say the inability to perform because of the pandemic. Before we do that, we have to see a couple of elements. What is considered to be a contract under the Cyprus law? So basically, in order to have a contract, we need some elements. The first element is an offer. We do have to have an offer. What is an offer? It's a statement by one person of a willingness to enter into a contract on stated terms. That means that I need to offer something to the counterparty. The second element is the acceptance, of course. What is acceptance? It's the absolute expression of acceptance of the terms proposed by the offeror. The acceptance should be unqualified. This is a fact. The acceptance should be expressed in a reasonable manner. However, under the Cyprus law, we should say that if the proposal states a manner under which the acceptance should be stated, and if the acceptance is not made in this manner, the offeror must, within a reasonable time after the acceptance is communicated to him, to insist that the proposal, the acceptance, should be communicated in a specific way. Absence or failure to do so equals to the acceptance. For example, what we see in practice is that we need the acceptance in writing. If it is not in writing and it is a verbal acceptance, despite the fact that the contract stated explicitly that the acceptance should be in writing, if there is an absence of any objection, then the acceptance is considered to be valid. Now, another element is the consideration. We need a consideration to have a valid contract. Without consideration, the contract is void. It's only valid, though, if it is expressed in writing and signed by the party to be charged, and it is made on account of nature of law or or love or affection. Sorry. Or it is a excuse me. Thank you. or it is a promise to compensate wholly or partly the person. I will not bother you with a lot of details about that. As we can see, if the promise is made in writing and signed by the parties, I need to remove this. How to make it? Okay. Sorry about that. If the promise is made in writing and signed by the party to a charge to pay wholly or in part the debt or which the creditor might have enforced payment, but for any law for the time being enforced relating the prescription or the limitation of actions. Another very important element is the legality of the purpose. It's only fair to seek protection if the legality of the contract exists. The consideration and object of the agreement must be is lawful unless it is forbidden by law, or it is of such a nature that if it is permitted, it would defeat the provisions of any law, or it's fraudulent, or it involves or implies injuries to a third person, or of course if the court regards it as immoral. The fifth element is the intention to create legal relations. Without the intention of the parties to create an official legal relation, we have no valid contract. Of course, we have the contractual capacity. The person who enters into a contract should be of sound mind or should not be disqualified by the contract. In Cyprus, a person is disqualified if there is a court order or if it is a minor, for example. Now, something else that we should ask ourselves is whether the inability to perform due to the pandemic is considered to be a breach of contract. This is debatable. A breach of contract is when one of more parties do not fulfill their obligations. They do not fulfill their obligations because they may do it and they do not want to do it, or because they are not able to perform. This is a million-dollar question, if you're asking. Now, what is a breach of contract? Is a situation where one or more parties involved do not fulfill their obligations. The obligations are outlined and agreed under a valid contract, and that contract must be signed. Usually, in the case of a breach, the non-breaching party should inform the breaching party in writing that there has been a breach, and that they should be fully aware that the contract is not honored, and they should take measures to correct it. It is only after a written notice that the court proceeding can be initiated. If the non-breaching party may cancel the contract if there is a severe breach. However, we do see a lot of examples where the contract was delayed or there were some clauses that they were not honored, and we might not seek to discuss on the basis of a breach of contract. Now, what will happen if we do have a breach of contract? Of course, the innocent party, let's say, will ask for compensation. The compensation for loss or damage as a result of a breach, it is being regulated by our law. We do seek compensation for any loss or damage caused to the other party where the loss should be calculated. We cannot go to the court and demand any sort of damage or loss. We must prove the damage. However, when an obligation resembling those created by the contract has been incurred, the innocent party who has suffered the loss might only recover damages for the loss as a result of such a breach, provided that it is not remote, and he needs to be in a position in which he should have been if the contract was properly honored and performed. Existing means of remedy to be taken into account are the following. In estimating the loss or damage arising from the breach of contract, the means which exist to remedying the inconvenience caused by the non-performance of the contract must be taken into account. Too much talking lately. Now, the other thing that we need to observe is when a contract has been broken, if a sum is made in the contract, for example, if there is any clause regarding penalties, the penalty clauses, we need to have a look at these clauses and take it into account. We do see cases where the parties might receive reasonable compensation that does not exceed the amount to be named, and if there is a percentage to be calculated when it comes to the compensation, it will the court will also take that into account. However, the non-performance because of the COVID, of the pandemic, might be considered as a force majeure. What is considered to be a force majeure in Cyprus? We don't have a clear definition. Despite the absence of the definition, what we can suggest to mention that is considered to be the act of God is an event or a series of events or circumstances that occur and that are not in the sphere of control of the parties involved, where such events might justify the non-performance of the contract or the delay. I want to make a parenthesis here and say that we do see a lot of contracts where the delay is crucial, which can result to the non-performance, especially when we have to do with contracts relating to goods that a delay will make the goods not sellable, let's say. It is common that parties wish to include a list of events that will be explicitly categorized as force majeure events. For example, wars, riots, floods, epidemics, pandemics, strikes, acts of state or government actions prohibiting or impeding any party from performing the contractual obligations. The force majeure clause is of utmost importance because it releases the parties from their liability to perform the contractual obligations. This is very important. Imagine to have millions of dollars value of contract, and suddenly, because of something that it is not in the sphere of control of the parties, to release the other party from their liability to perform. That means they will not be able to claim damages. It is very important. However, the event must be unexpected, to be beyond the control of the parties, and to have as a result the prevention of one or both parties to perform their contractual obligations despite taking all reasonable steps. This is to mitigate the effects of the event. This is crucial. We need to see actions, measures to be taken in order to mitigate the effect of the event. Now, what are the elements of the force majeure that we need to examine under the COVID-19? The elements are the unexpected event. Indeed, it was unexpected. Nobody thought that. Everybody was talking about a flu. The second thing is that the event should be beyond control of the parties, and the result of such an event to be the inability to perform despite taking all reasonable steps to avoid or mitigate the event. Now, Can we say for sure that COVID-19 could be considered as a force majeure event? It depends. It depends on the nature of the contract, the wording, and the scope of the clause. Despite the categorization of the outbreak as a pandemic, we might not automatically assume and categorize the pandemic as a force majeure event. Attention. The contract, in any case, must include clauses regarding the force majeure event, and the wording must be accurate. The second thing that we need to take into account is the nature of the contract. What is the nature of the contract? Is it indeed related to services that they were affected by the pandemic? The third one is that, was there any alternative solution for the performance of the contract? If yes, what are we talking about? Reasonable steps. Don't forget, there are steps to be taken that are causing so much expenses that it is simply not, the parties cannot afford it. There are steps, of course. One might say, I will charter another vessel, I will charter, I will ship it, I don't know, we will use airplanes to deliver the goods, but it will cost so much money that simply it will not be a reasonable solution. What is the result of the inability to perform the contractual obligation? Was there a delay to perform, or it was a total inability to perform? And another thing, we need an actual causation between the event, the pandemic, and the result, the inability or the delay. Very important. I just want to say a couple of things about the burden of proof. The burden of proof in Cyprus is that the party who is unable to perform his obligations under the contractual relationship bears the burden of proof. They must prove that the event has taken indeed place in the country where we expect the contract to be honored. The event had such an impact on the relationship that led to the inability in performance or the delay in performance. That reasonable measures were taken or attempted to be taken to mitigate or to avoid the result. And if such a case is brought before the court will examine the certain circumstances, the law applied, the intention of the parties. Remember the first slides that we've seen, that we need intentions of the party to create legal relationships. The legal relationship, this is what the court will examine. The court will interpret the force majeure clause, and the court will also examine what the parties understood by the inclusion of the force majeure clause before issuing a decision. Okay. Now, in order for a party to invoke the force majeure clause, the below should be taken into consideration. The existence of a force majeure clause. If a contract does not have any force majeure clause, it is not to be, the parties might not invoke the force majeure clause. The contract must include the provision of a force majeure event, absence of which does not allow the party to invoke the force majeure. Precise wording of such clause is of utmost importance. The majority of the contracts indeed outline lists of events that should qualify for such an event. Events, for example, like illness, disease, epidemic, or pandemic might include the COVID-19 and the virus to be seen and qualified for a force majeure event. The list of events might also include government acts, national emergencies. For example, we've seen the quarantine measures, travel bans, movement restrictions, etc., etc. We will see later on what is the difference between the virus as such and the government acts. Very crucial. The party which claims protection as a result of the outbreak of the COVID increases the chances of proving his case if the case is brought before the court. In order for a party to invoke the force majeure clause, the below should be taken into consideration. The second thing that we need to see is what is the actual event that will be examined under the force majeure regime. Will be the event, the actual disease, the pandemic, or is it the event that relates to the measures, including legislative measures taken by the government or other authorities in Cyprus or abroad in order to face the pandemic? What will happen if the event that is included in the force majeure clause expressly includes only events of the first or the second category? That means, what if the force majeure event, the list of events, includes only the pandemic and does not include the government measures? It is a matter of interpretation of the clause, specific wording of the clause, the intention of the parties, the nature of the contract, and the contractual obligations and the alternative solutions within reasonable limits, the causation of the events, and the actual result, that is a delay or the total inability to perform. Again, this is why we do suggest to include both, not only the pandemic, not only war, not only riots, but also to include also acts of the government and the authorities which will not allow, will prohibit the parties to perform. The third thing is the causation. We need a causal link between the event, the pandemic, and the inability to perform or the delay. If we wish to break down the causation, we need to see the pandemic or the governmental measures which are beyond control of the parties. We need to clearly prove the impact on the parties and the contractual relationship. We need to see that the impact forces the parties to inability to exercise their obligation or to delay the performance, and no reasonable alternative solution or no measures taken could lead to avoid or to avoid the inability to perform or the delay. If we get to see some notes about the court actions, in such cases, the claimant might seek remedies and compensation or damages based on the fact that the inability of the defendant to perform or the delay has caused the claimant loss or damages. The courts will examine the case based on the facts presented, on the laws applied, the intention of the parties, the interpretation of the force majeure clause as the parties understand it, and as the case law that the court will be based on will guide the judge in order to avoid or mitigate the loss of the damage. Attention, it is very important. The court will examine whether the clause of the force majeure will be used unlawfully by the defendant in order to avoid fulfillment of his contractual obligations as an excuse of non-compliance. If the court understands that there will be a fraudulent or unreasonable reference to the clause of the force majeure, then we will not be talking about force majeure, but about breach of contract, and damages will be paid. The other thing that we should be stating is that until now, we have no final decisions by the court in Cyprus regarding the treatment of the pandemic as a force majeure event. We hope that we will be having our first, even though we do have cases in the court, we do not have final decisions. We do expect it that end of 2021, beginning of 2022, we'll have preliminary court decisions and we will be able to see how the courts will treat it. For now, unfortunately, we don't. Now, another thing that we need to take into account is the doctrine of frustration. Based on the Cyprus contract, a contract to do an act which is after the contract is made becomes impossible, or by reason of some event which the promisor could not prevent to become unlawful, then the contract is void. This is considered to have as a result that the contract is invalid. The elements of the frustration of the contract is that the event should be unexpected, that the parties could not prevent the event or the possibility for such an event to happen, and that the event renders the performance of the contract impossible or unlawful. For example, We do have a war that takes place, God forbid, and that it is unexpected in a country, and two companies have entered into a commercial contract for chartering of ships, for example. Due to an unexpected situation and the proven consequences of the event, the contract could be frustrated since the outbreak renders voyages to enemy or prohibiting destinations impossible. Now, what are the requirements for one to claim the doctrine of frustration? We do need to seek a valid contract. The doctrine applies only to contracts which are valid because of the fact that the doctrine is specifically included in the Cyprus contracts law. The parties entering into an invalid or unlawful contract might not seek protection by the legal framework. It is only fair. The contract must not include any clauses about force majeure. It is of essence. We do not wish to see any force majeure clause if we wish to claim protection under the doctrine of frustration. So the contract must not include any clause of force majeure or any other clauses regulating the subject matter event. The event must be unforeseen at the date of entering the contractual relationship. So time is of essence. The unexpected event must have such an effect that the continuance of the contract will be impossible or unlawful. The Cyprus courts have ruled that the application of the doctrine is only applicable because the continuance of the contract is impossible or unlawful, and this action destroys the foundation of the contract. The burden of proof is that the courts require a very high threshold of such a proof of frustration and the causation between the frustrated contract and the loss of damage by the party. The party invoking the doctrine should not have contemplated the event or shouldn't have known or been able to know the impossibility or the unlawfulness of the contract at the date of entering the contract and creating the contractual obligation with the other party. So if the party knew or ought to know, we might not claim protection under the doctrine of frustration. The question now is that whether we can claim enforcement of the doctrine in the event of the pandemic. We don't know yet. However, we must see some parameters to be taken into account, the pandemic and the measures. While the outbreak of the pandemic could qualify for an event under the definition of the doctrine, we must ensure that the parties enter into contractual obligation prior to the pandemic and prior to the measures of the government. Parties that enter into the contract during the pandemic or after shall not be able to claim protection under the doctrine. So time is of essence. The second element is the jurisdiction. Not all countries have had the same impact to the pandemic. Despite the fact that we were all aware of the virus in December of 2019, the vast majority of the countries were unaffected. That was only, like we could hear from the news and the social media that there is this virus in China. It was too far from us. So we had no interruption of the business relationship. Parties that enter into the contractual obligation prior to the outbreak in their countries and prior to the decision of the measures by the government might benefit indeed from the doctrine. So place again is of essence. The parties might bring the case before the court and make use of the doctrine of frustration. As a general comment, it is noted that the courts in Cyprus are very cautious when accepting the doctrine of frustration, as this is due to the nature of the elements required to establish the doctrine. The court will apply a quite narrow interpretation to the doctrine, and it is only in only exceptional cases will accept the doctrine. Again, as we said, the threshold of the proof is very high. During the court procedures, the court will duly assess the facts in conjunction with the clauses of the contract. If the doctrine is proven to be accepted by the courts, the contract will be considered as invalid from the point of time where the unforeseen event has occurred. In this event, the parties will not be held liable for their inability to perform the contractual obligation, and no claims regarding compensation or damage will be available. This is why we do see that the courts are very reluctant to accept to categorize the contract as invalid due to the doctrine of frustration. Now, what can we recommend? The recommended actions are as follows. Prior executing a contract, it is advisable to request an opinion from a legal advisor as to the wording to be used. We always ensure that the obligations of the parties are clearly outlined. We need to ensure that the clauses of the force majeure event are extensive and include as many events as possible. Where needed, the use of events in a wider meaning can be used. For example, pandemic and illness. We do not have to start outlining all possible events and viruses and diseases. Simply using, making use of wide expressions, we can aim to categorize the event as a force majeure event. In addition, we need to ensure that the clause of the force majeure will also include the governmental measures, not only the disease, but also the measures. Upon execution of the contract, we need to ensure that all reasonable measures have been taken into account in order to avoid or mitigate the loss. Then we need to understand if the measures are reasonable in order to be able to claim that we took all the precautions and still we were unable to perform, or we were not able to avoid the delay. So, just to summarize our presentation, the contracts are valid only if there is certain elements. Breach of contract occurs when one or more of the parties do not fulfill their obligations. When we refer to the force majeure event, we discuss about events that is not in the sphere of control of the parties, and that this event led to the non-execution or the delay of in the performance. The COVID-19 pandemic might be considered as a force majeure event if such an inclusion has been made in the contract. If COVID is included in the force majeure list of events, the courts will release the party from the liability to perform contractual obligations. If the COVID is not included in the list of the force majeure events, the parties might seek protection under the doctrine of frustration. And if the courts are very cautious when we're claiming protection under the doctrine, and if proven, the courts will declare the contract as invalid from the point in time where the unforeseen pandemic has occurred. This is it from my side. Are there any questions? Should we gather everything at the end?
Yeah, I think we can gather at the end. I mean, I did want to say, obviously, this is a topic that I guess a lot of businesses are struggling with at the moment, and we'll have questions. So for any of the GCs in the audience, if you've encountered any difficulties or require clarification on this, then please do ask a question. We'll address it at the end. Can I just ask you, I mean, have you seen a lot of claims for breach of contract arising over the last couple of months, and have there been any attempts to claim such breaches as force majeure?
In fact, yes, we do have some cases, and some cases also reach the courts. However, because it's a very novel pandemic, we are not sure how to approach it. If it's something that it was explicitly, if the parties were lucky enough to include, as we said, wide clauses in the force majeure, such as pandemic or illness, we can see some, let's say, efforts to address these incidents before we reach the courts. However, in order to be comfortable enough to discuss about how the courts will approach this matter, we need to see final decisions from the courts. We have no case law in Cyprus regarding this type of inability to perform. However, we do expect that in a year's time, we'll be able to tell for sure what will be the the notion from a court perspective.
Okay. Excellent. Excellent. So, Andrea, we actually have, we have a question for you from a member of the audience. Question is, can you please discuss the situation of prepayment under frustration? So is it just, is it unjust enrichment? Is unjust enrichment the only way to claim back such money? Sorry, I'll have another go at that. Can you discuss the situation of prepayment under frustration? So is unjust enrichment the only way that parties can seek to claim back such money?
We do assume that the court will regulate the matter by under previous case law. However, we do expect that in this case where we have prepayments, it should be since the contract is invalid, any payments given before before the execution or before the provision of the services should be returned back. However, if there is no, let's say, willingness to refund, then we will seek unjust enrichment clauses. However, it's a matter of interpretation by the law and the courts.
Okay, excellent, thank you.
Of course, and the burden of proof will be to the party that refuses to, that seeks the refund.
Okay, excellent. We have a hand raised in the room, which is a function of Zoom. Tassia Pieri has a hand raised. Tassia, I don't know if you want to type the question in the box or if you're looking to come on and ask the question live, but maybe we can, if you can clarify that in the chat box, we can get back to you later in the session. Okay.
Thank you.
Excellent. Thanks, Natasha.
So we'll continue with our Natasha, and then we can address all the questions at the end if time allows us.
Yeah, excellent. Thanks.
Hi everyone. We move now to our third topic, which is the tax and employment issues and the wider impact of COVID-19 on local economies. COVID-19 generated an emergency situation as the epidemic continued to affect the economy, as well as our way of life in general. The main focus of business and governments as well is primarily on well-being, liquidity, and access to finance. As a response to the COVID-19 crisis that was triggered in March 2020, the Cyprus government published a series of legislative packages of emergency measures and announced a variety of mitigating steps to be taken in support of the country's citizens and the economy. Let's see an overview of the key points. Outline of VAT adjustments and amendments of deadlines in relation to tax return submissions. The aim here is to help taxpayers safeguard and preserve their cash flows, as well as lessen the administrative workload on the procedures. A summary of the main features is given below. Extension of deadlines for the payment of indirect taxes. For VAT periods that was ended 29th of February, 31st of March, and 30th of April, the taxpayer may postpone the payment of VAT due until the 10th of November 2020. The deferred payment can be made in installments until this date. It is important here to mention that no penalties or interest will apply in relation to late payments. There are, however, two criteria for this extension, which is for business not to have more than 1 million annual turnover based on the declaration made in 2019 VAT returns, and also the turnover to have been reduced by more than 25% compared again to last year's declarations as well. The Council of Ministers announced 20 categories of businesses to effect monthly VAT payments instead of quarterly, equal to 30% of the VAT liability. The tax department has sent an electronic message to the email addresses logged on the TaxisNet of the affected persons. The email informs these taxable persons of a temporary change in their VAT periods from quarterly to monthly. The categories of business that were chosen from the tax department is on the premise that were cash businesses that could still function and had the ability to contribute to the Treasury of Cyprus on a monthly basis. Some of them are electrical and fuel producers, water suppliers, the supermarkets, and of course the telecommunication service providers. Continuing to the measures is the extension of deadline penetrating to tax returns. The new deadline for the submission of the IR4 return, which is the company's tax return for the year 2019, is now 30th of June. The new deadline for the submission of the IR1, which is the individual tax return for the year 2019, is now on 30th of October. In relation to the installment repayment arrangement plan, which is through the Ariadne portal in Cyprus, is for the debtors which are included in the installment repayment arrangement plan for the overdue taxes. This payment of installments for the months of March and April is now extended by 2 months. The deadline for payment of social insurance contribution was extended. The deadline for the payment of March 2020 social insurance contribution in Cyprus has been extended now to 14th of May. In relation to the contributions to the national health system, which is called ESI in Cyprus, the increase of percentage of the contributions to this scheme applied as originally planned for the month of March 2020. But then, as you can see from the table, it then reverted to the previous rates for the months of April, May, and June 2020. In the first column of March is the increase rate for each category. Then it shows from April to June the reduced rates that we have prior to COVID. And from July and onwards, we will return to the new increase rates. Some other measures relate to other companies are the extension of the deadline for payment of the annual levy for the year. This is payable by all Cyprus companies by the end of the year. The submission of the 2018 income tax returns, which were due on 31st of March 2020, now moved to 1st of June. The company annual returns will need to be completed within the period from 1st of January 2020 to 31st of December, may be submitted to the Register of Companies until 20th of January 2021 without the imposition of any penalties. Companies and individuals with performing loans are entitled to suspend the payment of loan installments for a period of 9 months. Let's say that they have postponed their payments from March. The postponement will affect until the end of the year. The government decided to promote the heavily affected local industry to support, i.e. to support the tourism growth between June and September, and government funded totaling 11 million euros. The government has enacted the Rent Control Act 2020 for postponements of any evictions due to non-payment of rents until 31st of May 2020. Moving to any further business measures, the allowance of liquidity amounting to 800 million euros for financing small and medium enterprises through the Cyprus Entrepreneurs Fund. Beneficiaries will be small and medium-sized enterprises with a maximum staff of 250 people per company. For the purpose of lending to Cypriot small and medium-sized companies, the government has decided to work with the European Investment Bank to increase its lending plan by 500 million euros. The initial plan was 2 billion euros. The beneficiaries will be companies that have registered and operate in Cyprus and that employed up to 3,000 employees per company. The interest rate subsidy plan for new business loans to businesses, including self-employed workers who face a lack of liquidity as a result of the pandemic. The plan concerns loans that have been or will be contacted from 1st of March to 31st of December 2020. Beneficiaries again will be all business and self-employed persons, provided that they are not considered problematic under the European Commission definition. Economic stimulus measures refer to all performing business and public loans. Capital and interest will be frozen for 9 months, meaning the suspension of the collection of loan installments along with their interest. A state guarantee of 2 billion for businesses and self-employed, and any losses from these loans will be covered 70% by the government and 30% by the banks. I would like now to mention a new subsidy plan for very small and small businesses and independent employees. The aim here is to cover rent and other operational expenses of businesses. The amount of the one-off funding will be distributed to self-employed small businesses that were under full or partial suspension of their work and were included in the special plans of the Ministry of Labour in the period from 13th of April to 12th of May 2020, as seen in the below table. The number of employees arise up to 50 employees, and the maximum amount of funding could be 6,000 euros. The government, through the decisions taken so far, proves one more time that the determination to support the dynamic restart of the Cypriot economy. Moving on to the employment issues, it is worth mentioning that as soon as the first cases of COVID-19 in Cyprus were confirmed, immediate requirement for adoption of appropriate preventive measures by employers was initiated in order to safeguard a healthier work environment. It is worth noting that in an effort to limit the spread of COVID-19, the Ministry of Health has issued rigorous measures. In relation to the employer's obligation in the view of the risks of COVID-19, every employer is legally required to evaluate the work environment continuously and take all necessary actions in view of possible risk. COVID-19 has been an obvious danger in many businesses. Appropriate measures must therefore be taken to ensure health and safety at work. And examples of this type are providing disinfectant, antiseptic, and technical capabilities as an alternative to physical meetings, e.g. video meetings like the one we're having now. In practice, the Cyprus government stands ready to use the full flexibility of the country's aid rules to help Cyprus businesses and Cypriot citizens to overcome the adverse consequences of the pandemic. It has offered cash flow relief to businesses in a loss-making position and to employees, as well as through a business suspension plan strategy. The plan will be applied for any business that either took the decision to suspend its operations in response to the government request, full cessation of businesses, or continue operating as partly cessation, as a result suffered a turnover drop in the excess of 25%. It also includes financial assistance for affected employees. The key points of the plan are a 10 million euro small business support plan for businesses that employ up to 5 people, provided that they keep employees on the job and have had their turnover reduced by more than 25%. A special leave benefit is to be given to working parents with no help at home who have children up to The benefit is available to those who are not able, due to the nature of their work, to make use of teleworking or to use flexible hours. A special sickness benefit is to be given to employees of the private and self-employed sectors that fall into special categories and who, for healthcare-related reasons, are unable to carry on working with their workplace. Doctor certificates must be presented to the employer for sure. A special benefit shall be given to self-employed who have suspended their operations or who have partly suspended their operations and due to the outbreak of COVID-19 have suffered a decrease in their operations by 25% or more. Employees of businesses affected by the business suspension order should also expect special unemployment benefit, and business may participate in the scheme if its operations have been partially suspended and its turnover has decreased by more than 25%. A platform has been created by the government where each individual completes a specific form with its personal identification details along with their IBAN. Then another form is completed by the employer with the list of the employees that fall into the above mentioned categories. Once the data completed are reviewed by the authorities, then they proceed with the relevant bank transfer. The plan for the unemployment benefit is divided into 3 categories, with the last one ending on 20th of June 2020. The employer is allowed not to offer a wage to the employees during the period with special leave, special sickness, special unemployment benefits are payable by the government. If, for any reason, the employer has already paid the salary to the employee, it is allowed that the part of the salary relating to the period for which the benefit will be payable can be used as a set-off by the employer against future wage payments. Moving on, the government gives the option for the employees to work in parallel with the benefit provided, so they can reach their either gross salary or their net monthly salary. The employer, on the other hand, is obliged to contribute to the social insurances fund the relevant contributions according to the salary provided. Now, what happens if an employer tells employees not to come to work? Actually, it depends on the occasion and whether other alternatives exist to enable employees to work remotely. If an employer tells employees not to attend to work and the employees are not sick or in an obligatory quarantine or self-restriction, the employees should be paid their usual salary. If an employer options to close its workplace temporarily, then in certain cases, and depending on the nature of the businesses, employees may be able to work remotely. Let's see what happens if employees refuse to attend to work out of fear of infection. It is recommended that employees should work remotely where possible. Alternative options include taking paid annual leave or agreed upon unpaid leave, special leave for working parents, provided that the employee meets those requirements, or paid leave with the employee working lots of hours at a later stage as agreed with the employer. Employers could also assure employees that relevant protective measures have been implemented in the workplace. Does an employer have to allow employees to work remotely? In cases where it is a work from home policy, the employer must allow employees to work remotely and take all necessary steps to make this feasible. It is stated in my slides as a last point, the issue regarding the transportation of employees. This has been seized together with the quarantine in Cyprus nowadays. The wider impact of COVID on local economies is mentioning that further to a recent press release, a survey was conducted with participants of 45 CFOs from several countries on the effects of COVID-19 on businesses and the wider economic impact. Here it is worth mentioning that the major concern is the possibility of COVID-19 to lead to a global recession for CFOs in Cyprus at 73%, followed by a decrease in consumption and consumer confidence at 58%, and the financial impact at also 58%. The assumption that the pandemic ends today gives the potential to businesses to recover in 3 months' time. The majority concerns about the effects of COVID-19 on the business operation, whilst a small minority of CEOs believing that the pandemic is an isolated challenge that does not currently have any significant impact on their business. Reduction of revenue is highly probable in companies' revenue and/or profit, whilst only 4% expect an increase in revenue, like pharmaceutical industries. Upon the end of the pandemic cycle, the majority will be able to return to their normal business activities fairly quickly. The banking sector had a high intervention by the regulators and the government through the specific measures taken. The impact expectations is that new defaults and redefaults are expected to increase by the end of the year, especially the wholesale and retail trading, hospitality, and real estate construction portfolio. Interest income will not be materially impacted this year, despite the moratorium. In next year, 2021, interest income is likely to be impacted due to the expected wave of new defaults. The moratorium on loan payments and the fiscal stimulus package is positive as in general. However, it raises concerns around the final clauses of the guarantee scheme and whether it allows the quick and effective transmission of funds to the real economy. Banks reconsider how they will be able to meet customer needs. As regards to the tourism industry, there will be challenges through cancellation of bookings, revenue reductions, increased costs, and liquidity pressures. In Cyprus, many hotels will not operate during the summer period. Many businesses have suspended their operations, adjusted their working capital management, and are considering cost-cutting exercises. The recovery is predicted up until the end of 2022 as customer attitude is altered also and prefer not crowded places. Bookings of 2020 will be extended to 2021, meaning next year, and the new revenue is expected in 2022. Moving on to the action that needs to be taken through the impact, and the aim is to reduce the operating cost of businesses, plan changes in the HR as a result of the change in demand, and restructuring of the personnel, prepare macro projections until the end of the year, and follow strict budgets. Focus on limiting physical presence in business and banks and optimizing the cost structure through the digital transformation programs. Additional measures are needed by the government to support the tourism sector. Restructuring of group companies to avoid unemployment, reinforce remote working if the model works in matters of effectiveness, efficiency, creativeness, and overall productivity. Paths of business recovery as the future seems uncertain, and establish potential solutions and consider the effectiveness of government intervention to this global crisis. Thank you, everybody. This is the end of our presentation. Do you have any questions?
Natasha, thank you very much. We'll just wait a moment to see if any questions come in. So if anyone has any questions about Natasha's section, then please do ask them. I guess I'll kind of kick off by asking whether, so you mentioned some of the tax breaks that businesses and individuals in Cyprus have received. What's the situation for foreign investors? I mean, are there any measures that have been specifically aimed at foreign investors to Cyprus? Has there been any suggestion from foreign investors that they've faced discriminatory treatment here with the tax situation in Cyprus?
And the tax has not altered this year in relation to the tax percentage for Cyprus companies. We have heard through the government that they are considering reduces of taxes, but sure, for foreign investors, I think Cyprus is a good tacker to invest for their companies, and consider restructuring of businesses and include a Cypriot company within their structure for sure.
Okay. Can I ask what the kind of broader picture here is for Cypriot businesses and foreign investors? I mean, are there any opportunities that are going to arise out of this situation? Are there any things that people can maybe capitalize on, that it's a good time to invest in Cyprus? Returning to the theme of the webinar, I guess.
With regards to
with regards to the investments, we do consider Cyprus, as my colleague Natasha said before, it's a very attractive option. We do expect the government that will give more incentives to have more investors to come to the island and invest. At the moment, we do not have something solid, but we do expect the government to be proactive and give such an incentive as to foreigners to come and invest in Cyprus. We do have a number of programs that investors might invest in, and with some benefits also. And we do consider that they will have such procedures in place where any applications for any ancillary benefits as to such an investment will be examined quickly. We do refer to the naturalization of third country of other nationals through investment. That is that if investors come to the island and invest a certain amount, are eligible to apply and to receive, if a lot of conditions, of course, are met, the Cyprus citizenship. And we're talking about the European citizenship, not only Cyprus. We do expect the government, however, to give more incentives for foreign investments from individuals as well as companies, even to redomicile in Cyprus, not only to invest.
Add, Ben, to your comments, our government also supports these programs, and already existing programs have been undergone an accelerated procedure in order to ensure the investors that everything runs smoothly, which is a positive thing, of course, during the circumstances, considering the circumstances.
Excellent, great. Just waiting for any questions. I can see a number of people have their hands raised, which you can do via Zoom, but I don't want to put them on the spot and bring them onto the microphone. So if you have any questions, please type them into the question box. We'll be happy to address them. I guess the other thing which we've touched on here, but didn't go into depth on, is the impact on the real estate market. It's a big thing in Cyprus. I mean, has there been any notable impact on the Cypriot real estate markets as a result of COVID-19?
The real estate market?
Yes, yeah.
We expect that there will be some tremendous changes, to be honest, in the following 5 to 6 months. At the moment, everything is freeze, let's say, yes. But we see that there might be some reductions in the costs of plots and houses in the nearest future.
And the fair value of premises as well.
Mm-hmm.
Okay, excellent, great. Well, we don't see questions coming at the moment. Like I say, people have their hands raised. I don't want to put them on the spot by bringing them online. So I will say thank you to our wonderful presenters from Cyprus.
Thank you very much. And of course, we may assist any of the participants or answer any of their questions. They can simply contact us. The email address and or even our phone number is available on the screen. So feel free to contact us anytime.
Our individual presenters, they are all on our website, legal500.com webinars. So please go there. You'll be able to find their details through our website. As I say, we will be putting a video of this up and distributing it after, so you can rewatch it, formulate any questions and send them through. But look, thank you to everyone who joined us, and thank you to our presenters from Cyprus. Great pleasure. Thank you.
Thank you.